Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello and welcome. I'm Peter Afrasiabi, host of The Curious Lawyer, and today's Curious Lawyer series is looking at the Metaverse. Now, for those of you who've watched some of our Curious Lawyer programs before, you will have seen that they are fun, edutainment type programs. It's a good whimsical walk down off the beaten path areas of the law. We've done dog law, CIA law. We've explored the music of U2 to look at copyright law. We've even looked at James Bond and the franchise history to explore intellectual property transactions and litigation history and litigation tactics type things. So it's a full range of fun, off the beaten path, edutainment topics. And today we are going to look at the Metaverse. So if you look here on our first slide, you can see what we're assessing today. We are going to explore and understand first factually, what is the Metaverse? You've all heard about it. It's in the news, it's in the press. Facebook even changed their name to Meta because of this coming Metaverse revolution. So we're going to explore it to understand what it is factually. Then we're going to start looking at some of the general copyright, trademark, right of publicity principles and how they intersect with the Metaverse. This will give you a great overview of soft IP, copyright, trademark, right of publicity. So if you're a general practitioner, it's a really great program to, brush up on your general soft IP skills and get an understanding of how they may work for you and your clients in this coming new internet revolution that we're on the precipice of. We're also going to look at the sex law implications of the Metaverse and how this new technology and what it's creating and enabling is triggering a host of really new fascinating issues that fall under the rubric of what we could call sex law. And finally, we're going to look at some of just the general legal principles that intersect with the Metaverse, some tort and criminal law principles, and even some jurisdictional principles and issues that exist. So let's get started. Here on our next slide, we're asking the question, what is the Metaverse? Well, the phrase comes from Neal Stephenson's 1992 sci-fi novel, Snow Crash. And in that novel, he first used the phrase Metaverse to describe this future world that was future in 1992, obviously, where physical, augmented, and virtual reality all converge and collide into one new space. And that crazy, brave new future in 1992, well, it's here, and we're in it, and we're all about to be in it a lot more. Now, Facebook, as you know, recently rebranded to Meta. And the reason they did this is because the future realm of this metaverse, what we can call augmented and virtual reality, and the convergence of our experience with the internet vis-a-vis virtual reality fundamentally. This will be a place where people interact, where they engage in meetings, for games, travel, experiences, concerts, etc., you name it. And what happens is we will functionally be inserted into this visual space via a medium. The medium will be goggles, headsets, and eventually contact lenses that you barely even see or feel when wearing. And at the same time, we will have other devices that we can be connected to and experiencing in order to provide tactile experiences when we enter this visual world through our eyes. And so one way you can understand this, to contextualize this within the realm of the internet that we currently know, is that this is really Internet 3.0 probably. If you think of the very first iteration of the internet that all of us may remember back in the mid-90s when we first heard about this brave new world of the internet, and there was web browsers that came out so that we could interact with websites that were these sort of static informational bulletin boards. There was email, and there was this new thing. We would log onto a computer, those, our big, deep, heavy monitors, and we would type in a URL, and we would go to this place that gave us information. And it was a lot more efficient and cooler and better than perhaps going to the library and other types of things. And then that was Internet 1.0. Internet 2.0 was really sort of in the early mid-2000s. The internet evolved into what we can understand today as this social media platform where there's massive sharing of information, videos, text messages, communications on these very complex social media platforms that facilitate the further dissemination of your posts and content and videos and tweets and all of that. And that became a much more interactive version of the internet. But still, if you think about how we interact with the internet, it is still very similar to Internet 1.0. We sit at our desk, like you're sitting at your desk right now, and there's a screen in front of you, this physical screen, 12, 18, 24 inches away from you. And that mediates your experience with what the internet is delivering to you, with what websites are out there on the internet. And it is the nature of that that is fundamentally changing as the metaverse takes root, because you will no longer just sit and stare into sort of this big screen to see what's projected at you, the same way we've been watching TV, for the last century, basically. You will wear goggles instead. And so you will put these goggles on, and the goggles will project at infinity entire new animated worlds, entire new visual worlds that you will then be able to interact with, and you will have other tactile devices attached to you, maybe things you hold or things that you wear, things that you could have on different parts of your body, as we'll talk about in the sex law component in a little while, which will provide feeling and context to what you are seeing. And you will be able to navigate that world by moving your head, looking up, looking down, and changing what you see as if you were really there. And this is sort of that convergence that Neil Stephenson spoke about in his book. And so that's sort of where we are in terms of the goggles bringing you into the world. Let's unpackage this a little bit. And so here on the next slide, we're going to look at sort of one example of the vision of this collaborative workspace where people are engaged using their goggles and then using avatars that you may create for yourself to engage with others in this digital space. So if you watch this video from Microsoft, it gives you some great insight into how this is going to look and how we all may be interacting in this new metaverse. And so this is a great little video to watch for about 2.5 minutes, and then we'll be back in a second.
Connection is a spark that gives our lives meaning. It drives us to seek out others who feel the same way.
Okay, why don't you input the data and we'll take a look together. Hey Mari, what you got for me?
To find those who share our views, yet offer different perspectives.
So this net.
Look over here.
Challenge us with new ways of seeing.
That I think we should
Deepen our understanding. And enrich our lives.
最后一笔的时候，往前。
Great things happen when we commit to something bigger than ourselves.
Take a closer look at it.
place this here. Let's see how we go from there, okay?
This sense of collaboration and the feelings of connection it brings excites us.
Hey, just in time. I'm gonna move it slightly, okay?
It's yours, take it.
We have two planes right now on the same trajectory.
As we put people first, technology fades into the background and feels like anything but.
Aisha, what do you think?
I think if we had 330, maintaining 2800,
We'll be clear for approach.
Excellent.
This changes the way we see the world, and in turn, changes the world we see.
These numbers are looking great, actually.
There's promise in the possibilities, and what we see and create next will stretch the imagination.
Good morning, Sarah.
Morning.
Slowly coming towards the thumb.
A world without boundaries.
Good job. A lot better than yesterday.
Yeah.
Excellent. Slowly bring
A world where technology enhances, not limits, humanity. With people front, center, and in the spotlight. The future is here. And here can be anywhere. Introducing Microsoft Mesh.
So there you had it. That was a great example of what will be happening as we may appear with digital replicas of ourselves, or even you can create your own avatar of yourself. You can engage in meetings and other types of events where I may be here, you could be halfway around the world, but we could be physically, in a sense, seeing each other in this virtual reality. Either good replicas of who we are, or perhaps you want to create an avatar and look better. I'm going to look like Brad Pitt. You're all going to love me. And when we're in the metaverse. And that'll bring us to the right of publicity stuff I talk about in a little while, because I'm not going to do it and neither are you. But in any event, let's unpack it just a little bit more and talk, first of all, about the augmented reality phase of this metaverse. And so augmented reality is an enhanced version of the real physical world that's achieved through the use of digital visual elements, sound or other sensory stimuli that get delivered via technology. And so one of the easiest way to conceptualize this is just your eyeglasses, for example, that you wear. In a few years, you'll probably be wearing ones that are made by Apple and a whole bunch of other companies, and they may look like the readers that you buy for 20 bucks at CVS, but they're not going to be readers. I mean, nothing like it. They will project images at infinity. So you will wear the glasses and you will be able to see all manner of amazing things, data, information, even map directions. Turn right here, just like you see on your physical screen, you'll see them projected at infinity through your glasses. At the same time, though, you will be seeing the regular world. They won't be completely distorting the regular world. There will be overlays on the real world. So you could think back, for example, to the early Terminator movie, even in the 1980s, where they showed kind of what the Terminator saw, and he looked at people and saw them, and then it gave him information about those people. That is the type of application that's imaginable in this what we could call Brave New World, where you'll wear your glasses as you're walking around the mall, and it may well be that your glasses can scan the face of someone and it'll tell you who it is and some information about them, whatever they can pull up on the internet, for example. Or it'll be directions, turn right here, turn left there, or other digital media that can be placed into the real world that you're in. And so watch this video for a minute. You'll get a glimpse into sort of how augmented reality works. It's already here with many glasses, and it's coming even faster. And my own personal opinion is it'll come a lot faster when Apple releases her Apple Glass one day. So here, watch this video. That's augmented reality, and now on our next slide, let's look at virtual reality. So virtual reality is an artificial environment that's created with software fundamentally, and it's presented to you, the user, in such a way that you're almost suspending your disbelief, your belief. You accept this world as a real environment. Now on a computer, virtual reality is primarily experienced through two of the five senses, sight and sound. And so you wear these goggles and both see and hear an entirely new visual landscape that's digital, or it could even look very real. It could be literally video footage. Maybe you go to the incredible fords of, Iceland or a glacier somewhere, and you're looking as if you're really there. You see it, you hear it. It'll be warm in your house, no doubt, but it's that type of experience. Or what you'll be seeing may well be digital replicas and creations, not cartoons, so to speak, but much like very, very real looking video games, you can be inserted into those types of spaces or other customized spaces. The sky's the limit, really. So let's watch this video clip real quick, just for a minute or so, and you'll get a sense of how the metaverse will look in virtual reality.
Imagine you put on your glasses or headset and you're instantly in your home space. It has parts of your physical home recreated virtually, it has things that are only possible virtually, and it has an incredibly inspiring view of whatever you find most beautiful.
Hey, are you coming?
Yeah, just gotta find something to wear. All right, perfect.
Boy.
Oh, hey, Mark. Hey, what's going on?
Hi. What's up, Mark?
Whoa, we're floating in space? Who made this place? It's awesome.
Right? It's from a crater I met in LA.
This place is amazing.
Boz, is that you?
Of course it's me. You know I had to be the robot, man.
I thought I was supposed to be the robot.
Whoa.
I knew you were bluffing.
Hey, wait. Where is Naomi?
Let's call her.
Naomi.
Hey, should we deal you in?
Sorry, I'm running late, but you've got to see what we're checking out. There's an artist going around Soho hiding AR pieces for people to find.
3D street art? That's cool.
Send that link over so we can all look at it. This is stunning.
Okay, that is something.
That's awesome. Wow.
I love the movement.
Wait, it's disappearing.
This is amazing.
All right, so we've got the building blocks out of the way, and now we want to dive into some of the law that really is going to intersect with this world, and some of the obvious areas of law that already, no doubt, having watched those videos, you're priming your mind, you're thinking about this metaverse and what it means to your practice, you see it already. This immediately trips over copyright, trademark, right of publicity, and it immediately also dovetails into issues related to sexual behavior, sexual conduct, and sex law and events that can happen in the metaverse. And it also raises fascinating issues about jurisdictional questions, tort law, contract law. I mean, imagine in some of those videos you saw people getting together in a meeting to have a conversation, to make a decision about what to do. So you may be watching this video right now in Philadelphia, and imagine if you and I enter into some room in the metaverse where we want to have a conversation about, maybe we're going to partner up on a legal project. And we meet, we talk, we engage and share information, and you're there, I'm there with our avatars, and we're literally talking and engaging and moving, and we see each other doing that in this virtual world. And then we enter an agreement. And so the question then will become, okay, let's say one of us breaches it. It's not going to be me, maybe it's you, but someone breaches the agreement, we got to have a piece of litigation about this. Well, what law governs the agreement? Where was the agreement even entered when it was entered in this sort of virtual digital room? Was it in your backyard, your physical backyard, my physical backyard, or was it in some virtual world which is subject to terms and conditions that define where the jurisdiction is? All of these fascinating questions are what we're going to start diving into. So let's start with copyright in the metaverse, and let's go over some basic copyright principles you see here on the slide. Copyright exists for original expressions fixed in a tangible medium. These are things such as art, computer programs, drawings, poetry, writings, and the like. Now, the requirement is sort of twofold for copyright: original expressions and fixation. For purposes of originality, the threshold is very, very low. Courts do not like to get involved in artistic judgments about the artistic merit of what you've created. And so you can see here the very, very low standard for originality, for sort of what we would call artistic ingenuity. And there's really not much artistic ingenuity needed. And here you see from Justice Holmes in 1903 in the famous Bleistein case, where he said, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves final judges of the worth of pictorial illustrations, outside of the narrowest and most obvious limits. At one extreme, some works of genius would be sure to miss appreciation. At the other end, copyright would be denied to pictures which appealed to a public less educated than the judge." So for purposes of originality, what you see there is the standard that's long been part of copyright law, and it's part of copyright law today, and that is, it's a very low standard. Courts don't like to get engaged in artistic merits determinations. And so if an artist puts a circle on a canvas, the court's not going to say that's not art. That's just not the business of courts. And so right now you're listening to this, you're doodling because I'm boring, and your doodle, you're getting a copyright in it. So you're getting something out of this program beyond the CLE, you're even getting a copyright. So that doodle, let's say you're doodling right now, and it's a cool little doodle you're making. That's the originality requirement. Your doodle, assuming you're not copying it from somewhere else, it's your own doodle, that meets originality. The next requirement is fixation. It's got to be fixed in a tangible medium. Well, you are. Your pen on the paper right now is fixing in a tangible medium your expression, your original expression. And so that gives you a copyright, which is why if you take a piece of clay and you mold it into a piece of pottery, you have a copyright. If you create a computer program or you write your book in Microsoft Word, as it's being recorded into the computer, that's being fixed in a tangible medium. So here's what you don't do. You have a great idea for an incredible poem, and it's the best poem ever. It's only 5 words, and it's a love poem, and you want to share it with your loved one. So you get a guy to go up in one of those airplanes that does airplane writing with smoke and whatnot, and you put the poem up in the air, and it's an incredible 5-word poem, but it's in smoke that just disappears away. You haven't fixed it in a tangible medium, so you haven't actually got a copyright yet. So that's fixation, that's originality. So now, on our next slide, let's talk about who owns the copyright. The author owns the copyright. That is, you making the doodle, you're the author. And so that author owns the copyright at the moment of creation. And the author owns it unless it's given away by some mechanism under the Copyright Act. In other words, it's assigned in a writing, which is required if you want to assign a copyright, or or some of the exclusive rights that copyright gives one are licensed away somehow. One of the questions we now have to start asking ourselves is, how does copyright collide with the metaverse? Well, first of all, the world you enter, that digital world that you're interacting with when you go into the metaverse, it may be a forest, it may be a meeting room that Microsoft gives you to meet and hang out with people. Maybe you get to go into some cool version of Star Wars that Disney is going to create and allow us to enter and interact with, characters and robots and all that stuff from the Star Wars universe. Well, whoever creates that world is going to own the copyright, of course, to that world they've created, the software that creates that metaverse. But what about materials you publish when you enter that world? Because remember, these worlds are going to be virtual versions of our current world. So maybe there's a mechanism when you go, for example, into one of the worlds where you can take some content that you've written and you can publish it. You can post it, like on social media right now, but you'll post it. You'll blow it up for someone to look at and read. What happens to that? Do you own the copyright still? Have you given it away? Have you licensed it? These are the types of questions that will be asked by users of the metaverse, and are very important for us to know and for our clients to know, because the ease with which we share information in the real world and we shuffle in content will be equally the same in the metaverse. And so a lot of this will be governed by the terms of use of the given platforms that you enter. And so let's take a look right now at existing standard social media terms of use, because for many of you who haven't read them, you may be stunned to see the breadth of what you are giving away, or your kids are giving away, when they're getting on social media and they're posting things. So look here at this quote. It says, and this comes from Instagram, "By displaying or posting any content on or through the Instagram services, you hereby grant to Instagram a non-exclusive, fully paid, and royalty-free worldwide limited license to use, modify, delete, add to, publicly perform, publicly display, reproduce, and translate such content, including without limitation distributing part or all of the site in any media formats through any media channels except content not shared publicly, i.e. your private stuff, that won't be distributed outside the Instagram services." So if you stop and unpackage that, you take this incredible photograph of a sunset. Maybe it's the most amazing photograph of a sunset that's ever been taken, and you blast it out on your Instagram feed to the whole world, right? Well, what you've already done as the author and owner of the copyright to that photograph that you took is you've already given Instagram a non-exclusive, paid up license to use, modify, publicly display, reproduce, even adapt and change that content you put out there. They have that right. So they could actually take that content and do all manner of commercial things with the content that you would never have imagined or even expected. You just think that they're going to leave it up on their site to share with everyone, and there's no other sort of additional monetization of it by Instagram per se, but they have every right to do it. And that's a very standard term of use in social media companies. The custom of the industry may be currently that they don't do that, but those rights exist. So you can imagine that this becomes even more important when you're not limited to 100 characters or however many characters a tweet allows you to post, or some limited amount of content that you can put into Instagram or Pinterest or these other social media sites that very narrowly circumscribe the format of the content you use. Now you can put anything and everything in the metaverse, and what governs it are going to be the terms of use, and they'll be very, very, very important in future battles that are on the horizon. All right, now let's take a look at the virtual reality world, the metaverse, and we'll go deeper in music, and we're going to go down the niche of music, and we're going to take a look at concerts in virtual reality. And we want to start wrapping our minds around what happens when you go into the virtual reality world, this metaverse, and you go to a concert. How does it work? How does copyright law and music work when you're in this visual digital space as opposed to a real physical space? Who owns it? And one of the questions we're going to look at is, are we going to lose our cover bands because of copyright law? Is copyright law going to deny us the right to go into a cool bar late in the afternoon in the metaverse, meet up with your friends from all over the world? You may all be in different countries, sipping a drink physically in those countries, but you're literally looking at each other and through your goggles, hanging out in a bar, having a great time, and you want background music. You want to hear a cover band playing the great oldies, all the great stuff from the 80s. Those were my oldies. You want to hear it all, right? You may not be able to. Let's start by taking a quick look at the metaverse and concerts and music and some of the amazing ways that copyright law is touching us as this world develops. So watch this video for about 1 minute and 15 seconds and we'll be right back.
You mentioned something about the social aspect of it, and I think that's really interesting because I think people find going to a concert to be a very social experience in and of itself. So how does that change in VR?
Yeah, I mean, one of the cool things about the Wave, we just launched internationally, and when you go in there for these shows, you actually meet people from around the world. One of the cool things about social VR is that it kind of closes the distances between people. One of the shows we did last year was actually for an Iranian artist named Ash Kusha, who was banned from coming to the US due to Trump's travel ban. And we actually let him perform his show for the first time to a US audience who was exposed to this totally different type of art, and both musical and visual.
Wow.
All right, so let's take a look on the next slide about copyright and music in virtual land, for lack of a better word. So copyright has long given a public performance right for physical venues to allow others to perform music live. This is why bars and restaurants have live music, playing oldies, or, even newbies, whatever it may be. But that public performance right that exists within the realm of copyright law, that exists such that artists can go out and publicly perform music, is a fundamental function of American copyright law that exists by way of the performing rights organizations. And the legal structure that exists with performing rights organizations is that they effectively have amassed all of the content of music, and then they give blanket licenses to venues so that the venues can play music in these commercial spaces. So if you go into a bar or restaurant, you just hear music in the background. You go into some other public space, you hear music, or you go to a public space where someone's going to actually perform music live. All of those rights are given by the performing rights organizations, and people license them. And so social media sites also generally have blanket license that protect users who may post some content with music that comes from the performing rights organization's catalog, and there are some blanket licenses for that much. But let's ask the question, because that's just to perform live in a bar, in a restaurant, at a concert venue, for example, the background music before the concert starts. How do you attend, though, our happy hour? We want to go to a happy hour in a really cool virtual reality bar. It's going to be a great looking bar. We think we're in Hawaii, and it's awesome. But it's a video created world. And how does that work? Well, this gets us to the question of sync licenses for music. And this is the complexity under US copyright law currently that raises this difference between the right to perform music publicly live versus, which you can get that license from a performing rights organization just on a blanket basis, ASCAP, BMI, and the like, versus what happens when you want to play music live but it is synced to some video or visual file. And so copyright law, of course, as we discussed, has this public performance mechanism through performing rights organizations where you can get your blanket license. But that doesn't give a right to then take the music that they may license you and sync that music to some video file that you're creating. So you can't get a license from them to perform that music live and also record it with some image, perhaps of you recording live, and then record yourself. Because the moment you reduce it to a recording, this audio-visual work, it can be video, it can be images, it can be film. But the moment you do that, that is not covered by the performing rights organization's grant of rights. that right under the Copyright Act still belongs unequivocally to the original copyright holder. And so in order to reduce a song in that way, sync it with an audio-visual creation that you're recording and making, you need what's known as a sync license. And to get the sync license, you got to go to the original source of the copyright owner. There is no, in other words, there is no equivalent to ASCAP and BMI for sync rights. And this is what creates problems already in our sort of nascent growing video world, which has been sort of accelerated by the COVID experience in terms of how does one do this. And so we can look here on our next slide as we keep walking through copyright world and music, because we're still, remember, we're still in our bar, we're having a great time, it's all fun, but are we listening to a cover band playing the great New Order music from the 80s, or the Smiths, or some cool stuff from, you know, the Beatles back in the day, you name it? Are we listening to the cover band play it? We're going to find out soon. So part of this issue has been already experienced heavily in the COVID era, where we all suddenly went into this near virtual world, this remote world on Zoom, and we were all heavily engaged now in behaviors that we weren't normally doing on Zoom or Skype before. I mean, before COVID, we'd jump onto Zoom for a quick 5-10 minute business meeting. But COVID and the isolation suddenly created these opportunities for people to say, hey, hold on, we want to have group events. Well, we're going to have 50 people getting on all at the same time, and we're going to play some music, and we're going to stream it live for the world so that people can join us in our webinar and our Zoom meeting, where we're all now engaged in making music together, for example. Or we had virtual choirs and shared a cappella events and virtual happy hours we even all engaged in, right? At least I did. So what happens? Well, here's the problem. In this realm of these sort of Zoom virtual performance recordings, you know, Zoom may well have the performance right organization license that they've got cleared, but you still need a sync license. And this creates problems because the streams that are syncing music to video content need their own license. And in fact, there's even blocking technologies that exist to pause or mute stuff if you don't have the sync license, so that it doesn't, you know, create an infringement and trigger a problem for the platform. Now, this then brings us, of course, to the metaverse, because we are going to enter this world that will obviously, just like our real world, where you walk around, you walk into a public place here, you're going to walk into a public place in the metaverse. Will there be pre-recorded music playing in the background? Well, if there is going to be pre-recorded music playing in the background, because it's in the background now of a digital, visual, virtual world that you're experiencing, that then raises the question of how you're not really live like you're live now, such that you can only have a performing rights organization license and be okay. When, for example, when you walk into Neiman Marcus and they're playing music in the background, they have got their license and it's a public space and it's all okay. But when you walk into Neiman Marcus in the metaverse, now you're in some visual world, right? This is digital, it's video, it's a video world you're looking at, and it's synced with the music. They need a sync license. This creates huge problems. And so you can imagine as the metaverse expands and grows and wants to replicate the real world, especially since you will be looking at that world using really your eyes and your ears heavily, those are the two major senses we use, music becomes a very, very important component so that the metaverse can replicate the real world. And copyright law currently doesn't have a mechanism that is sort of the analog to the performing rights organization for sync licenses. And this is an area of copyright law that is going to have to catch up with this modern world we're entering, so that we can all go to that cool digital bar in Hawaii and listen to music. Now let's shift from copyright to trademark. What are trademarks? Well, the common synonym of a trademark, of course, is just the brand name. You can think of things like Coke, 7-Up, Chevy, Google. Those are trademarks that belong to those companies, and they denote a brand. They denote a product or service that's offered in commerce and that's associated with that company or that single source. What can be trademarks? Well, words can be trademarks, just like those, Coke, 7-Up, Chevy, Google. But also sounds can even be trademarks, numbers, shapes, even smells. So there's all sorts of different things can be trademarks. But fundamentally, they have to connote a given company's goods or services. They have to be a source identifier. And when it's applicable to goods, we call it a trademark. And when it's applicable to services, we call it a service mark. So my law firm, the law firm of One LLP, we have a registered service mark in our name because we are service providers. We're lawyers, professional lawyers. That's what we do. This trademarks even extend to product packaging and certain non-functional product configuration features. And so you can think of the non-functional ornamental look and feel perhaps of a website that's very distinct and unique, or of product packaging. That can even be, garner trademark protection. It's known as trade dress, but fundamentally it's a trademark. It is a visual depiction of something that denotes a single source. And trademarks, of course, fundamentally have to be used in commerce. It can't just be an idea in your mind, or it can't just be something that you intend to do. If you have a trademark on bottled water, you need to actually be selling bottled water. So let's look on the next slide here about trademark issues in the metaverse. And so you can already imagine, there you have a picture of, what's really some depiction of sort of a version of Zoom, but where we even put up digital avatars already that you can throw up into your Zoom thing. But imagine now you're in the metaverse where you have a digital avatar, and in this metaverse, maybe you want to sell goods in the metaverse, right? People are going to have digital avatars, and just like we want to wear a suit here, we want to wear a cool suit there, and my digital avatar, I want to wear a Rolex. Are you going to buy a real one or a fake one? Do you have trademark infringement if you put on a fake Rolex on your digital avatar in the metaverse? These are the fascinating questions that are raised. Or, for example, 1LLP, my law firm. Maybe in 10 or 20 years in the metaverse, we will have a virtual space that you can go to in the metaverse to come into our law firm, like literally a physical building and a place that you can see, so that you will come into our lobby or a conference room and you can sit and talk to me. You can be anywhere in the world. You want to know about American copyright law, I can put on my headset, or by then maybe it's even contact lenses, you'll put them on too, and we will be suddenly in this virtual space looking at each other and talking to each other, and you will see everything that the 1LP people, or our software developers at least, will have created for the look and feel of our law firm. And what if above 1LP you see the Nike swoosh? Right? Trademark infringement. How is Nike going to patrol that? They're going to need robots running around the metaverse to make sure people aren't taking their trademarks and using them in order to steal business, because I'd put the Nike swoosh above myself because it tells everyone, oh my gosh, you must be really, really good because, Nike's associated with you or endorsing you, right? So these are the types of immediate trademark questions that pop up instantly that are very difficult to patrol and deal with, and are going to require then the service providers providing these platforms, just like service providers now have obligations to take down material and to patrol to some extent what's going on. These same questions are going to arise in the metaverse for what regulates the obligation of the providers of the world that you're in to make sure there's no infringement, or is it the burden of the rights holder to go out and find these places? And so you could imagine right now in Internet 2.0, as many of you may know, there are these spiders, they're called, or bots that just crawl out on the internet looking for example, infringement. So if you have a great photograph that you took, you can put it into this bot and it goes out and sort of invisibly crawls through the whole internet to find places that may have the same image so that you can see that, oh, there's an infringer. You'll have these similar bots flying around or doing whatever, maybe flying right by you in the virtual world as you're standing talking to someone, looking to find infringements in a much more complicated way, as you can imagine. So these trademark issues accelerate in a massively complicated way to patrol and find and address infringement in the metaverse. And we're going to now take a look at a case, because there's already been some cases, not of the metaverse, but of very early versions of what will be the metaverse in terms of specific video games. And so let's take a look at this game. This is Humvee versus Activision. This comes out of the Southern District of New York in 2017. And basically, this is Activision Blizzard's game called Call of Duty. It's a war game where it's a first-person game where you have your big screen, you have your gun or your controller or whatever, and you're playing the video game, and you're in this world. Now, you're still being mediated. You're in your living room, and there's a TV, but you're in that world. It's a whole world that Activision's created where you can make your character do all manner of things in this battlefield you're on. And so in the game, Activision Blizzard, it's the American army, they're going to war and whatever, and so the cars in the game look like Humvees. And so the owner of who makes the Humvees was unhappy, and they sued, saying, look, you didn't get the right to use our Humvee. It looks like our Humvee. It creates the idea in the users of the game that Humvee, the company, is associated with or has endorsed the brand in this video game. And Activision Blizzard defended and said, no, we have every right as a version fundamentally of artistic expression to create this fictional world, and we have to have, cars that look like cars that the American Army uses. And so here you see a quote from the court that agreed with Activision and rejected Humvee's trademark lawsuit over the look and feel, the trademark of the Humvee. And the quote says, "It was metaphysically possible for Activision to have produced video games without the presence of Humvees." And that, of course, is a truism. "If realism is an artistic goal, then the presence in modern warfare games of vehicles employed by actual militaries undoubtedly furthers that goal." So fundamentally what the court was saying is that because this increases Call of Duty's feeling of realism in terms of trying to create this very real version of wars, it served a purpose way beyond anything trading on the Humvee brand. And so therefore it met these artistic tests that courts have employed that relate to de minimis uses of other people's trademarks in the art form. And so one way you can think of this is sort of, for example, Andy Warhol painted those famous paintings of Campbell's Soup. He didn't need to get a trademark license from Campbell's Soup to paint that. He had the right to do it as part of artistic expression. And this is sort of a similar concept and version of that. And it comes from a famous case, Rogers v. Grimaldi from the Second Circuit, where there was an Italian movie made called Ginger and Fred. And it was about these two Italian cabaret performers who performed dance routines kind of similar to Ginger Rogers and Fred Astaire. And it was called Ginger and Fred. But Ginger was sort of the only, other than the dance routines being similar, Ginger was the only other thing that was associated with, for example, Ginger Rogers. And Ginger Rogers sued, saying that, you used my name, you've created this false association between me and the movie. And the courts rejected it, saying, no, this is a fictional movie about dancers. And, it was this sort of oblique, de minimis use of her name that was of minimal relevance to the film, and it didn't denote endorsement or sponsorship. And so that artistic use of the name for whatever it connoted was acceptable under the trademark laws. And so that has created this sort of doctrine fundamentally that the Activision case hinged on, where courts will protect the use of trademarks in works of artistic, creative, expressionistic type works. And so you can imagine that is going to be tested heavily in the metaverse, because it's one thing to have a video game where that's going on, but then imagine where you create entire universes that you enter that will have all manner of similar things, like Humvees or Porsches or Ferraris or whatever it may be, right? In any universe you go into, replicating the real world that will be there. They're not trading on them per se. They're necessary really to create this sort of fictional, version of reality that we all want to go into. And so Humvee versus Activision is one of these early cases that is going to be sort of, is almost a pole star in the ground about what's coming. Now another case here comes from the Ninth Circuit, and this is a little more recent. This is ESS Entertainment versus Rockstar. And this is reported at 547 F 3rd, 1095. It comes out of the Ninth Circuit in 2008. And this involved the the famous video game Grand Theft Auto. And in the Grand Theft Auto universe, again, it's kind of like that Call of Duty game. This is just different. It's sort of versions of Los Angeles, New York, or cities that you're driving your car through, engaging in car escapades and all manner of things. I don't play the game, so I don't know. But in any event, what happened is that the video game created this, inside the game, a strip club exterior and logo that looked like a real world strip club and logo. And so you see here, ESS Entertainment owned the Playpen, and it owns the sort of the trademark to the look and feel of its strip club called the Playpen. And that same look and feel and the name, the Playpen, was then used in the same looking building, was dropped into the video game as a place that you would be driving by in your car and interacting with and doing whatever. And so they sued for trademark infringement against the makers of the game. And like the Activision Blizzard game and like the Ginger Rogers case we spoke about, the court looked at it and said that there was no infringement because it was artistic expression in a game fundamentally protected by the First Amendment. And so that kind of use doesn't connote association, endorsement, sponsorship, which are the linchpins of the Lanham Act, the trademark laws in America. Instead, that's protected expression. And so these are some early volleys in this emerging trademark war that will be happening, no doubt, in the metaverse as it expands more and more, because commerce is going to follow into the metaverse. And so it won't just be playing a game with some incidental use of something, but we may all be engaging in commerce in the metaverse, using Bitcoin and doing who knows what. And as it replicates the real world more and more, the trademarks then will go from being artistic uses more and more to being commercial uses, which start colliding with the Lanham Act. Speaking of commercial uses, this brings us to right of publicity. And we're going to look here at where right of publicity collides with the metaverse. So first, let's answer the question, what is the right of publicity? Well, it was first conceptualized in the seminal work of Brandeis and Warren, and this is a law review article in 1890 called The Right to Privacy. And it existed at common law in various states for decades, and it was codified in California, for example, in the 1970s. It's been codified or recognized by common law now in 35 states. And it's a distinct right to copyright and trademark. And actually, the US Supreme Court has addressed it in a case in the 1970s, where coming out of Ohio, where it looked at Ohio's version of the right of publicity. And so in this case, Zucchini versus Scripps, it involved a broadcast company that filmed the human cannonball. And his whole persona was getting into a cannon, launching out of the cannon, doing something, and landing. And that was his whole act. I mean, that was his persona. It was that 20, 30 seconds of being a human cannonball. And it was then recorded and broadcast on TV. And the recording of it, obviously the company owned the copyright in the recording. They're the ones that filmed it and recorded it and fixed it in a tangible medium. But he sued saying, you didn't have the right to use my right of publicity. This is my likeness, my image, it's who I am. And so he brought suit against the news company, Scripps Howard Broadcasting Company. And he brought it, under state law, Ohio's right of publicity, and this eventually winds its way up to the US Supreme Court because the defendant argued, no, we have sort of this First Amendment right to film it and then publicly broadcast it for newsworthy purposes and whatnot. And the US Supreme Court said, no, the Constitution will not act to protect a news provider in that context when it has taken and used someone's likeness in that manner without permission. And so that decision was a very, very important decision that sort of really blew open the lid, you could say, on right of publicity. And since then, the value of right of publicity for individuals, celebrities in particular, has exploded even more. And so let's take a look on the next slide at the scope and term of the right of publicity in California. And this is just, I use California because it's an exemplary statute. It's kind of it's similar to many across the nation, but it protects against the unauthorized use of one's name, likeness, voice, signature, or photograph in commercial advertising. The prima facie case asks whether there was a knowing use of the plaintiff's protected identity. Was the use for advertising purposes? Was there a direct connection between the use and commercial purposes? It lasts for different amounts of time. For deceased, it can last for 70 years after death. It's considered a transferable asset, so it's licensable, descendable property right. But only if at death the deceased person's right of publicity must have had commercial value. So I have no commercial value, obviously, so at my death, my children aren't going to get any right of publicity for Peter because there's no value. But if you are Marilyn Monroe or Brad Pitt, and Marilyn Monroe is a great example of where there was a big litigation problem because of where she died, but James Dean, those people who have legit right of publicity value at their death, then it can last for 70 years. So now let's take a look on the next slide. We're going to check out Tom Cruise here. So watch this video for about a minute and a half.
That's fine. Oh, it's it's a little embarrassing. It reminds me. I was once in Russia. I ran into Gorbachev. He said, Mr. Movie Star, are you nervous? I said, no, Mr. Gorbachev, I'm not nervous. I don't. He goes, well, remember how much a polar bear weighs. I said, polar bear? He said, enough to break the ice. It's the last time I've ever seen Mikhail Gorbachev.
All right. So, first point is, that was not Tom Cruise. You're saying, wait a second, of course that was Tom Cruise. It literally looked and sounded like Tom Cruise. You can't be serious. The mannerisms, everything about it was Tom Cruise. Turns out it wasn't. That's a deep fake video. And so this is where already we have massive issues about right of publicity and these emerging technologies like deep fake videos. that afflict celebrities, but they also can afflict anyone. And this has come up a lot in terms of revenge porn and really damaging stuff that's been done by people using either fake porn or revenge porn to really damage people in their persona and their right of publicity and who they are on the internet. And so you can imagine then, obviously, the exponential growth of this in the metaverse, where you'll be able to create deep fakes of people and personas and create them and sort of go around being whoever you want to be, or looking like whoever you want to look like, or sounding like whoever you want to sound like. And so if you want a great example of, for example, stealing or being the capacity to steal someone's voice with technology, just go Google or go to YouTube and punch in Val Kilmer voice, and you will see an incredible video of this technology that has replicated Val Kilmer's voice. And as you may know, Val Kilmer sadly had throat cancer and he's lost his voice, and he doesn't sound like Val Kilmer, the Iceman that you know anymore. But this software literally replicates his voice. And when you hear it, you say, no way, it's Val Kilmer talking, but it's actually software. Well, that technology too could be employed to allow a virtual law firm to have a virtual person telling you what a great firm we are and how we can help you. And that voice could be Tom Cruise's voice or Val Kilmer's voice or Marilyn Monroe's voice, you name it, right? People stealing rights of publicity in the metaverse in this complicated way. So this technology is emerging, it's exploding already. And so on the next slide, we can start thinking about, okay, so we're in the metaverse where you create your avatar. And your avatar is, what you want to represent you when you engage with others. And this already starts redefining our own personhood, who we are, who we visually look like, who we visually sound like. What do you want it to look like? And on the one hand, you could be going out there stealing people's rights of publicity, which is going to have to be patrolled and dealt with by our legal system. And on the other hand, you can imagine it getting even more complicated when you want to alter yourself, your voice, your look, or something into a new, different version of your own personhood in the metaverse, which isn't stealing someone else's, it's your own creation, which is now yours and it's your identity. And then that may be infringed or taken by other people. Are they infringing your right of publicity? Well, I mean, it's not you out here, but it's you in there. And the more that we interact and live in that metaverse that's being built, the more those avatar extensions of us really are versions of ourselves. And the courts are going to be then forced to grapple with questions fundamental to our identity and our personhood. Are these digital beings part of our personhood that can be protected? Or of course the easy questions are the welcome bots at the law firm that look like famous people. That's going to have to be protected too. This starts getting into our sex law component here, and we're going to look first at sex dolls and the right of publicity, because technology is already leapfrogging society and leapfrogging the legal system in a massive way. So the Houston City Council passed a zoning law in 2018 to ban this Canadian company known as Kinky Dolls from expanding to Houston, because the Kinky Dolls company wanted to open a sex doll store in Houston where they would rent out sex dolls to customers on site. I mean, in effect, it's a sex doll brothel. Because the sex doll technology, these physical sex dolls, has become so advanced that the dolls look literally like people. I mean, it's the craziest thing if you go out and research this and study it. They look like people. They even are now creating like this apparently they feel like people, this sort of tactile feeling. Dolls can make sounds and talk and do all these crazy things. So this technology is exploding, and it creates problems for the right of publicity, obviously, because if sex dolls are made to look like people or sound like people, they are then stealing people's rights of publicity. And this world already exists. Adult performers, male and female, have licensed their right of publicity to sex doll companies to make sex doll versions of themselves, so that these are both male and female adult performers. And so those things are already occurring on the licensed front. And on the next slide here, you can already see in this technology unlicensed uses. There's a picture of a sex doll there, and that's a clothed version of the doll, because this is a PG program. But that doll looks like a young Israeli blogger, this famous influencer, Yael Cohen. She's a very successful Israeli influencer. And she first learned in 2019 that a company out of China had made a sex doll that resembles her. I mean, that looks like her, and is named Yael, using the same name as her. And so clearly they are trading on her right of publicity, her name and her likeness, to make a sex doll version of her. As of today, I just checked yesterday, that sex doll is still available on the internet. This goes to show the massive problems that exist for people in terms of patrolling the creation and the use of their right of publicity in foreign countries, and then bringing them into here. This then, as you can imagine, amplifies exponentially in virtual reality world, because we now will be having virtual sex dolls and virtual sex. Believe it or not, it's true. So take a look at the next slide. This is a metaverse sex patent. You heard it here first. You see there the patent. It's a method and device for interactive virtual control of sexual aids using digital computer networks. There is a screenshot I took of sort of how it works. It's mind-numbing. I can be sitting at my computer, you're at your computer, the internet mediates both of us, and right now it's a computer, but the computer will become goggles. So we're now mediated by this virtual world where we're both in this virtual space, even though we may be 2,000 miles away. And as you see, we are each connected by some mechanism to a sexual stimulation device. That is a metaverse sex patent, in other words. It will facilitate the ability for people to have sex thousands of miles away using physical aids for sort of to simulate sexual behavior, for lack of a better word, via the internet, where you are looking at it and it looks like you're engaged in sexual relations. This then, of course, gets to our question of sex dolls, virtual reality in the metaverse, because already in the virtual reality worlds that have been created, there are virtual reality strip clubs where people are able to enter these strip clubs wearing their devices and have a virtual reality experience in a strip club, seeing naked people stripping. And then also with stimulant devices like in that patent we saw. And so this means necessarily that we are confronting staggering right of publicity questions on the horizon in the metaverse. And I think of all the areas of law, right of publicity law is definitely one that you can very clearly see is going to have the strongest amount of problems, because it becomes so easy to create digital avatars of people such that men may enter a virtual reality strip club and customize who they want the woman to look like, and they could pick any woman they know or any woman from history, right? That could be digitally replicated because of the ease of technology. Now, causing immense harm, stealing people's rights of publicity, causing massive, emotional, psychological harm and damage. I mean, these are profound questions that the technology is raising and is creating, because we can have bespoke virtual sex dolls. So what this gets to, I think, on our next slide here is really the need for a uniform right of publicity so that we can preempt the field. I mean, currently we have 35 odd states with a patchwork regime of protection. Different states have different varying levels of protection, different amounts of duration. And this has a profound impact even on assessing the lawful use. I mean, part of the problem could become that in certain regimes, in certain states, it may even be legal to be doing what you're doing, and there may not be a developed right of publicity law to protect a person from being abused in this way. Because of this inconsistent patchwork of state laws, we have forum shopping. It also creates massive expense and uncertainty for businesses to even be able to operate and do business or assess the value of transactions, because they don't even know what they can or can't do. Maybe there's a legitimate amount of fair use on the right of publicity for certain sorts of behaviors in one state, but not in others. This chills expression. This conflict in state laws, creates sort of that level additional transaction costs for businesses. And so I think what we really see is that these modern technologies that are already here, deep fake videos on the internet, the Israeli sex doll case example we saw, already technology is showing us that we really need a uniform rule. And so just as for all the other areas of intellectual property law, there is federal jurisdiction. Copyright and patent are exclusively federal. Trademark and trade secret are concurrent state and federal, but there is a uniform set of federal standards. I think it really argues for the case now that right of publicity, that other area of intellectual property that's in some sense the most valuable intellectual property to all of us, because it's our personhood, it's our identity that gets protected. We need a consistent set of national laws so that if there are violations, we can have a consistent amount of jurisprudence. You can go into federal court, get nationwide injunctions, the better ability to sort of seize things at the ports and sort of shut down the internet or websites that are doing this in the metaverse. And so I think that ultimately this argues for the need for a uniform federal right to preempt the field. Now let's look at our last little segment here before we close out on jurisdiction. And so the other members said, well, we're all around we're in this guild in this video game, but let's all gather in the video game to just have a moment of silence or and to sort of honor the person who died in real life. And so they all entered the video game world for that purpose. They didn't go in with their weapons because they just went in as a guild to have this sort of ceremony. Well, meanwhile, another guild had learned that they were going to have this kind of funeral, and they weren't going in with their weapons. And so this other guild went on the warpath and said, oh, let's go destroy them and take their power, weapons, whatever the gain is. And so they went and assaulted this kind of virtual funeral, and you saw those explosions, killed them all, took their power and whatnot. This created a whole sort of melee within the game and within sort of the broader community about what are the standards of behavior that are acceptable. I mean, does it violate the terms of use? It didn't violate the terms of use, really, in terms of the guild chose to go in without weapons, and when you're in that world, you go in and you fight other guilds, and if you get killed, right? I mean, those are the sort of the things. And so what's happening already, and you can imagine then, is that the behavior in the virtual world that would be criminal out here in the regular world may or may not be unlawful in that world. And this gets to then the question of what is going to be the set of governing legal standards? Because it's one thing to enter a video game that's got a very defined purpose, right? You go in as some creature in a guild engaging in fighting, and okay, that's a limited thing. But what happens when we're in the metaverse for hours every day, just the way we're out in our real world hours every day, and we're doing some commerce and we're doing meetings? Well, what happens when things happen, right? What if someone somehow enters a malicious code and kills your avatar, the avatar that you've spent years building, right? I mean, if they kill me, it's criminal. If they kill your avatar, what is it? How do you deal with it? How does tort law address and deal with this? And so these are the huge future legal issues really for coming generations, as we really have these extended versions of ourselves in online worlds. When you start thinking about like defamation and torts and conversion, when your accounts get terminated or your avatars get taken. And some of this, again, we have some early sort of indicators in some cases, and the last case we're going to look at is Bragg versus Second Life. And so Second Life, as you may know, is one of these virtual worlds that's been created where you can kind of have a second life, where you can own real estate and you can do all these things in this sort of world that exists in the computer, and you have your own personhood and an avatar. And so, with a set of rules and commerce and whatnot. And this has been around for, 10, 15 years, Second Life. And this case involved someone whose account was terminated in Second Life because he'd figured out some way to acquire the land cheaper than you're allowed to, some sort of backdoor way of doing it. And so he had his account terminated for sort of effectively cheating in Second Life and doing something outside the terms of use. And so he then lost this sort of existing property right that he had built up, and he was frustrated by it. So he sued. And one of the fascinating questions is the jurisdiction question it raised. I mean, he sued in Pennsylvania against the company and against the owner of the company, who wasn't in Pennsylvania. And the owner of the company said, you can't sue me in Pennsylvania. I've never been to Pennsylvania. I've never done anything in Pennsylvania. And it was not a general jurisdiction case. It was a specific jurisdiction case. And so the question was, has that person done something specifically in Pennsylvania? And one of the fascinating quotes out of the case is the court looked at it, and you can see here the quote. The court says, he, being the defendant, was the hawker sitting outside Second Life's circus tent, singing the marvels of what was contained inside the metaverse, right, or an early version of a metaverse concept, to entice customers to enter. Once inside Second Life, participants could view virtual property, read additional materials about purchasing virtual property, interact with other avatars who owned virtual property, and ultimately purchase virtual property themselves. And I bolded it for you. Significantly, participants could even interact with Rosedale's avatar in Second Life during town hall meetings that he held on the topic of virtual property. And so what the court said is, his act of going into this virtual space with an avatar and engaging with a plaintiff who was in Pennsylvania meant he had entered Pennsylvania and subjected himself to specific jurisdiction. So that is a very early case that will no doubt be tested in our future metaverse litigation. So stay tuned. This is The Curious Lawyer on the Metaverse, but there's going to be another metaverse one in 5 years. I'll do an update with probably some crazy new cases that we'll have seen as this world starts exploding. So here on our final slide, let's take a look at some of the conclusions just to put in, really into focus for the metaverse. There is no universal set of laws to regulate intellectual property or our personal behavior, contract or tort law within the metaverse. And this absence of a universal set of laws is something that you can see in the future being remedied if indeed it becomes that we all spend more and more time in the metaverse. Contract and tort laws are going to get tested in terms of whether, where, and how contracts are entered. torts are occurring, what law jurisdiction governs, how we attach physical world law to metaverse world law and behavior. World regulators are definitely going to be employing very different standards for how these platforms that we enter are able to collect personal information about us and our avatar and who we are behind there. All these different personally identifiable information that may be in there that may be collected and then used for marketing or whatever. That's all going to be heavily regulated by different forums. And we have fundamentally, as you saw in our general overview of copyright, trademark, right of publicity, a real collision of those three areas of law with the metaverse. And what we see really is that we will definitely need even more now stronger national standards to protect rights holders. And we really need, both in the copyright realm, a modernization of copyright law to address this sync license issue that we talked about. And we definitely need some modernization and almost nationalize the right of publicity law to really protect people, to then facilitate the growth of this new technology and this new, Internet 3.0. Finally, related to that, we saw that the sex space is going to have massive potential for injury and damage to people. And it's a legal regime that really, because of our right of publicity laws currently, it's too parochial to protect people. We don't have national revenge porn laws properly to deal with sort of, terrible, sexual type abuse stuff that can happen in the virtual world, with, likeness taking or deep fake taking, deep fake revenge porn taking, for example. You can imagine things. And so we will need much stronger standards to protect people in that space. So, you, the Curious Lawyer, I hope you enjoyed it today. Watch our other Curious Lawyer videos. And as ever, if you have questions, please email me. Love to hear from you always. Thank you.